Right, so when Yvette Cooper's Home Office declared Palestine Action a terrorist organisation back in July, it was meant to show strength, provide a shield to Zionism, all proof that Labour could swing the same authoritarian hammer as the Tories, only with even more pro-Israel expediency. But now the hammer has hit the handler, hasn't it? The Court of Appeal has ruled that the government's ban must face open judicial review. Starmer and Co's attempt to appeal that ruling has failed, and the government is now sweating like a fishmonger's window, having made their case even weaker through this latest failure, this latest balls up. Starmer's grown-up government has stumbled into its own Kafka novel, secrecy on trial, legality in the dock, and every excuse they've ever made evaporating under oath. The only terror visible now is inside Whitehall, where officials are discovering that in the end the Terrorism Act can in fact cut both ways. Right, so everybody break out their very smallest violins in the world possible and play them to your heart's content, because it's devastating news for Keir Starmer's government. He's dropped this afternoon as the United Kingdom's Court of Appeal has issued a ruling that they really didn't want to see written down whatsoever, because it allowed a full judicial review of the decision to prescribe Palestine Action now under the Terrorism Act of 2000 to very much go ahead. The government's appeal against this, desperate to avoid it, has failed completely. For the first time, a British court will examine whether a government can lawfully use terrorism powers against a domestic protest movement whose actions have been disruptive but not violent. The case was, of course, brought by Huda Amori, the group's co-founder. The Home Office has tried to block her challenge, insisting that such matters should be handled in a closed tribunal away from public view, because God forbid we should see what's happening, what's being said, what evidence is being ponied up. The Court of Appeal rejected that argument. Its judgment, therefore, now ensures that the legality of the prescription will be tested in open court, where evidence can be heard and government reasoning will be scrutinised. In an even greater setback, Amori's team can now apparently argue on 2 more counts, arguing against the legality of the ban. So not only has Starmer's government weakened their case, they now have to defend themselves against 2 more counts in connection with it. Oh dear, how sad. Never mind. The ruling represents more than a procedural setback, though. It is a direct challenge to the authority of Keir Starmer's administration, which has attempted to build what passes for its reputation on control and credibility. It's that big. The decision exposes a government that tried to bury dissent beneath bureaucracy, only to find itself dragged into the light, kicking and screaming. When Yvette Cooper signed that prescription order back in July, she invoked the Terrorism Act Section 3 powers. That order made it a criminal offence to belong to or support Palestine Action, with penalties of up to 14 years in prison. The justification was national security, though the record shows no evidence of violent intent on PA's behalf. The group's actions were acts of civil disobedience, not terror. According to verified reports, the Joint Terrorism Analysis Centre, JTAC, did not recommend prescription to Cooper, but she went ahead anyway. That detail, confirmed by multiple media outlets, indicates that the decision originated in politics, not intelligence. That's going to have to be defended in court now. Open court. The government sought to reassert control after a series of embarrassing protests that highlighted Britain's role in arming Israel. Overnight protests, therefore, got redefined as extremism. Now, with the courts demanding transparency, the same government will face the same instrument it once used against others: accountability. The offences cited, property damage, trespass, obstruction, they were already covered by existing law. Using the Terrorism Act to extend punishment from those acts to acts of identity just blurred the line between public order policing and national security. And the timing of it all mattered as well, didn't it? The order arrived as the government was facing mounting criticism over its silence on Israel's bombardment of Gaza and the UK's ongoing exports of components. The Bryce Norton red paint incident that embarrassed ministers so much simply exposed military cooperation with Israel. The inference, which is grounded in all the timing of these events, is that prescription was less about preventing harm and more about managing the optics. And the result was immediate. The arrests surged. People displaying the Palestine Action logo were questioned under anti-terror powers. Peaceful demonstrations were dispersed, but they kept on happening because people wouldn't have it. A protester who once faced a fine for obstruction was now risking 14 years in prison for exactly the same act. The deterrent effect was swift and deliberate, but also ineffective. The arrests of pensioners and people in wheelchairs just made a mockery of the government's overreach. Palestine Action therefore decided to challenge the decision at the High Court, seeking an interim suspension before Parliament's vote. The court refused that, ruling that ministers had acted within their statutory authority. The Home Office declared victory and claimed the issue was settled, but that ruling addressed only procedure, not the substance of it. Amori's lawyers therefore filed for full judicial review, and when they did, the Home Office sought to divert the case to a closed tribunal, effectively removing everything from public oversight. It was that manoeuvre the Court of Appeal has just struck down. They're not winning this one. The attempt to avoid daylight had produced the very exposure government ministers like Cooper and Starmer didn't want, that they feared, that their loyal media friends would have provided them cover for, should it have gone behind closed doors. The appeal judgment means that internal communications, risk assessments, ministerial correspondence can all be ordered for disclosure. Officials understand what that means, don't they? If the record shows that prescription proceeded against professional advice, as we are already told it did, the government's narrative of national security necessity will collapse completely. It will expose their lies and their true intent behind this, which we all largely suspect, given the donations from the Israel lobby, is all to do with Israel. If Starmer and Co pleaded national security for Israel's sake and that gets exposed, well, they'll be shown up as having demonstrated more loyalty to that state than this one, and in my view, that should be politically unsurvivable. Surely that would be tantamount to treason. Anyway, we're getting a little bit ahead of ourselves there, perhaps. The court ruled, however, that existing procedures already allow sensitive information to be protected whilst maintaining open justice. Therefore, that left the Home Office with no place left to hide. It will have to justify in public why a non-violent protest group has been treated as a terrorist organisation and why they defended that so much. Disclosure carries particular danger because it will also reveal process, not just the outcome. Which department initiated this move? Did any legal advisor warn against it? Was the Prime Minister informed before or after it was signed off on? All the answers and more will define the next phase of the crisis before them. The government's messaging has remained consistent since July, which for somebody as two-faced as Starmer is quite a surprise, really, isn't it? But that's that Palestine Action posed a risk to life. The facts show no casualties, no evidence of planned violence, no threat beyond disruption. It's always looked like overreach to so many of us. The dissonance between rhetoric and record is what makes this ruling so damaging now. If the High Court finds the prescription unlawful, the consequences will be systemic. The order would have to be withdrawn, all related prosecutions abandoned, and those arrested solely under its authority released and or compensated. Over 1,000 arrests and more than 100 charges are already recorded. Even partial compensation is going to cost millions. More damaging still would be the precedent set. Ministers would no longer be able to invoke terrorism law without clearing set evidential thresholds. A judgment against the government here would also constitute a formal declaration of executive overreach. For Labour, it would obliterate the image of steady competence that distinguishes it from the previous administration. The prescription was Starmerism in action, managerial authoritarianism asserted through the law. And if that law collapses now under review, the governing philosophy will all collapse with it. And Starmer's reputation as a former lawyer will be decimated no matter how many times he reminds us he used to be Director of Public Prosecutions. Even a narrow defeat would reverberate. It would show that the judiciary, long deferential to national security claims, is no longer willing to grant automatic trust. The challenge is not confined to Westminster, of course, as I spoke about the other day. In Scotland, where criminal law is devolved, prosecutions under the same prescription order are already being contested. Activists argue that enforcing the ban violates their rights to free expression and assembly under the Human Rights Act of 1998. If Scottish courts agree, the order could be unenforceable north of the border, even if the government ends up winning in London, which would create a constitutional crisis over this matter. So institutionally, the stakes are actually even higher. For 2 decades, Home Office culture has operated on the assumption that national security, just invoking those 2 words, will place any minister involved beyond ordinary accountability. A High Court ruling to the contrary would puncture that doctrine. It would compel Parliament to legislate safeguards, perhaps independent verification before prescription, or mandatory judicial review within fixed timeframes. Such reform would represent a rare contraction of executive power in a field where expansion has been constant since the days of Blair. Officials understand that possibility, which is why the department has fought so hard to avoid an open hearing. The Palestine Action case fits a wider pattern, therefore. Over recent years, Britain has witnessed a steady criminalization of dissent. It's been a picture in several Western nations now, the US, Germany, France. The Public Order Act of 2023 as an example, restricted protest rights, while the prevent strategy has extended surveillance from security threats to political activism. The prescription of Palestine Action was a logical extension of that culture. It was designed to show toughness and decisiveness, but instead it's exposed an authoritarian reflex, and then it might have finally gone too far for the system to still support it now. Labour's leadership often equates control with competence, yet control exercised without transparency has led to decay, and this could be what we're seeing now. The government's insistence on managing narrative rather than confronting facts has produced exactly the scenario it sought to desperately avoid: legal defeat accompanied by moral exposure. Palestine Action's case demonstrates how a law intended to prevent terrorism can be repurposed to suppress embarrassment. The judicial review will now decide whether that repurposing crosses the line from governance into illegality. The Court of Appeal's ruling created a constitutional turning point now. It's established that prescription decisions are subject to open judicial review, a principle never before confirmed. Ministers can still redact intelligence material, but they can't avoid scrutiny altogether. The High Court is now going to test whether Palestine Action's actions meet the legal definition of terrorism. The definition requires serious violence or the threat of it, directed at the public to influence government policy. The verified record shows property damage, but never violence against people. If the court finds this threshold unmet, as surely it must, given what we know already, it will conclude that the government expanded the definition of terrorism beyond its intended scope. That finding would have consequences reaching far beyond this case. It would call into question every single prior use of the Terrorism Act against protest movements. It would also validate warnings from civil rights lawyers that the Act's language has become dangerously elastic and in desperate need of tightening up. The forthcoming hearing will involve disclosure of documents detailing how and why the July decision was made. Even partial release could reveal contradictions between internal advice and public justification. The image of government lawyers leaving the Court of Appeal empty-handed after losing the secrecy bid has already become emblematic of this shift. Power moving from the executive to the judiciary, where in legal terms is where it absolutely should be. Shouldn't even be a question, really, should it? The content of those documents is the heart of this fear. If, as reported, the JTAC assessment did not support prescription, it will confirm that ministers acted against expert advice. That would make the prescription not only unlawful, but knowingly so. Disclosure may also expose political pressure. Correspondence between ministers and lobby groups and defence contractors could show whether external influence accelerated the decision. The government's insistence on secrecy fuels the inference that such links exist, and we already believe this was all done for the sake of Israel. So how deep do those ties now go? Even absent scandal, disclosure will dismantle the protective opacity on which national security policy making has relied on for years. For Starmer's administration, the reputational cost is already immediate. Whether the documents prove misconduct or simply misjudgment, the outcome is the same. The myth of unassailable competence falls apart and disintegrates. What was once portrayed as this strong leadership now appears as a brittle authoritarian one exposed under pressure. The legal stakes merge with the political ones. A ruling against the government would trigger reform of the Terrorism Act, as is desperately needed, introducing judicial oversight before prescription, inviting compensation claims from those wrongfully arrested. Politically, it would mark the collapse of the government's central narrative. Starmer positioned Labour as the party of order after years of turmoil. The Palestine Action case has turned that promise on its head. The more the government insists it is acting lawfully, the more the courts and public demand to see the evidence. Socially, the case will redefine the limits of protest too. A government defeat would embolden campaigners across all movements, environmental, anti-war, civil rights, to resist intimidation under counter-terror law, because we know it can be beaten. A government victory would normalise the idea that disruptive protest can be treated as terrorism, though, which would be catastrophic for all of us. Either way, the judgment will set the boundaries of dissent for a generation. What remains uncertain is what those hidden files will show, and who inside government pushed the decision forward despite the warnings. That unanswered question now drives public curiosity more effective than any press release on this could. We want answers. We demand answers. We want to see names. We want to see these people held to account. The moral inversion at the centre of the case is stark. A government that arms an occupying power labelled the people protesting those arms as terrorists. The activists' actions targeted weapons production linked to Israel's campaign in Gaza, a conflict described by multiple humanitarian organisations as catastrophic because it is a genocide. But there were no casualties in Palestine Action's operations. The goal was disruption of supply, not intimidation of the public. To call such acts terrorism is to drain that word of all meaning. The effect is to criminalise conscience and protect complicity. This judicial review is therefore not just about legality, but about morality as well. It asks who the real threat to public safety really is, those who protest against war crimes or those who are facilitating them. Within Labour, this issue has reopened ideological fractures. There are MPs and members of the party who warned that prescription would criminalise dissent. They have been vindicated by this finding. The leadership's decision to fight transparency has deepened the sense of authoritarian drift, and just how terrified they actually are being found wanting. For Starmer personally, this risk should be existential. The prescription was his government's signature act of security politics. It was meant to display authority. Instead, it displayed authoritarianism. It symbolises just how fragile his ego is. Every procedural loss amplifies the perception that he's lost control of everything. Internationally, Britain's reputation is also at stake. The United Nations and rights groups have criticised the use of counter-terror powers against pro-Palestine activism. A judicial finding of illegality would confirm all of those critiques and place the UK in the category of states that use security law to suppress political opposition. That would be positively Putinesque, you might say. Even without a final verdict, the narrative has shifted. The government's insistence on secrecy has become the story now. The longer it delays disclosure, the longer it gets dragged out before that judicial review, the more the public will end up assuming there's wrongdoing at stake here. The more the media may potentially dig up. Independent media are more likely to do so, of course. Control has given way to exposure, though, and exposure is now shaping the political weather around this story. Starmer's personal history reinforces that continuity as well. As Director of Public Prosecutions, he oversaw cases under the very legislation now under review. The irony is absolutely delightful because it couldn't happen to a nicer person. The prosecutor has become the defendant. If the government loses, the fallout will be extensive. The prescription would be quashed, obviously, compensation claims would be filed, costing into the millions, and political accountability would have to be demanded. Parliamentary committees would call for explanations, Cooper's decision-making would be re-examined, and Starmer's endorsement questioned. In my view, their positions as ministers would be untenable, surely. Institutionally, a defeat would recalibrate the relationship between courts and ministers as well. It would demonstrate that even in matters labelled security, legality remains paramount. For civil society, it would prove that judicial mechanisms still function as a defence against authoritarian overreach, too much of which they've got away with for too long in government. Every attempt to control the narrative has instead reinforced the perception of guilt. The more the government insists that secrecy is necessary, the more its credibility disintegrates. What began as an assertion of strength now reads as an admission of weakness. Starmer's government has traded moral clarity for procedural control and authoritarianism. The Palestine Action case reveals the cost of that trade. A politics that values order above truth eventually loses both. The collapse of the government's credibility is not hypothetical, it's observable. Every court loss, every forced disclosure, it all chips away at the image of competence until nothing's left but fear. Beyond personalities and party politics, the case restores a constitutional principle that no branch of government is immune from legal scrutiny. For 2 decades, national security has been used as a shield against such accountability. The Court of Appeal's judgment has shattered that now. You will be held accountable on these matters. The High Court proceedings will test how deep that breach runs, though. If the judges reaffirm the independence of the judiciary in security matters, it will mark a rebalancing of British constitutional practice, long overdue. If they defer to the executive, it will confirm the consolidation of unchecked power, and God help us all. Either way, the Palestine Action case will now stand as a benchmark. It will determine whether protest remains a right or becomes a privilege subject to ministerial tolerance. But that won't stop protests happening, because protesters will always protest when they are being wronged. What began as a bureaucratic order has become a referendum on the integrity of government itself. The facts are plain. A protest movement targeted arms factories. Embarrassed ministers retaliated with a terrorism ban. The courts intervened. The sequence is now uncontested, and its implications are vast. The government's fear is rational because the danger is real. Documentation, exposure, accountability, all the things politicians hate the most. Every sealed file is a potential indictment of judgment. When power begins to fear the evidence, you know it's being wielded by the wrong people. This forthcoming High Court hearing, this judicial review, could compel the release of materials ministers have fought to suppress. Those documents may reveal not only why the prescription was made, but who insisted on it against advice. That prospect, not the protesters, not the headlines, is what truly terrifies this government. And they should be afraid, because accountability has finally come knocking on their door. For more on the Scottish side of this story, as I went into the other day, do check out this video recommendation here as your suggested next watch. Please do also hit like, share and subscribe if you haven't done so already, so as to ensure you don't miss out on all new daily content, as well as spreading the word and helping to support the channel at the same time, which is very much appreciated. Holding power to account for ordinary working class people. I'll hopefully catch you on the next vid. Cheers, folks.